Good morning, everyone, and we are again dealing with another lesson because it's a Monday and the first part of the lesson on public international law. But you have to remember that we will be dealing with only for now the general concept of public international law. And actually, this is very close to my heart because I am teaching public international law in one of the law schools here in Cebu, and I also had a good grasp of public international law when I was still in my pol sci um, um, time, or like when I was still in my undergraduate. Then I participated, or I joined the mooting team of the law school where I graduated, and I started as a researcher, then an oralist, now acting as an assistant coach, trying to help other students who are into like interested of mooting competitions. Now, today's lesson again is about public international law, and before we go deeper with the topic or on the topic, we have to know the definition of public international law or international law. And this is a basically it's the law that governs sovereign nations or states. And now the question is international law a real law? However, I want to dissect this question in such a way that you should consider that this question is based on the traditional thinking of what law is. And before we will answer this question, we should know first what are states. And according to the Montevideo Convention, and there's always a question of recognition as an element of statehood. And as you can see in our screen, the top three would are not questionable, are non-questionable elements: population, the people composing the state, the territory being occupied by the population and can sustain enough the population, and also the government that has to do with the management of the population within that specified territory. And now again, the question is recognition an element before a state could be considered a state under international law? And the scholars are divided as to how to answer this, because there's a group that would say that recognition is a must, but there are those that says actually it is an attack against the theory or the principle that states are independent and sovereign as compared or in relation to other states. So in this lesson, we will not be dealing actually on how to answer this. We will park it, and later in a later lesson I will surely be answering this. Now, again, as we were talking about, is public international law a law? Now, in answering this question, we have to put it side by side with national law and the perspective, the usual perspective of what a national law is. And there are three common elements which would help us answer the question whether public international law is a law. Why? Because as to the first element, hierarchy, there is no hierarchy between and among states, as accordingly, um, states are considered equal, independent, and sovereign from each other. So no state cannot control, or else it is an intervention of the sovereignty and independence of states. And also, public international law is something consensual or discretionary, especially that no state is forced or obliged to sign and ratify a treaty or be bound by the terms and conditions of a treaty or agreement with states of which such state is not a signatory. And also, there's a problem with enforcement, because if you compare our domestic laws, we have the national government assigned to do the enforcement of the laws enacted by the national by the Congress or the legislative department of the government. So these three elements or these three areas or aspects or however you call it would demarcate or help us identify what separates international law from national law. Now, as we move forward, we will be dealing with the sources of international law according to the ICJ statute, and by ICJ we mean the International Court of Justice. And you have to understand as early as now that these listing are also the same sources of which the ICJ base its decision when it has to decide cases filed by states against another state. Now, treaties, before we end this part of the lesson, we will have to discuss specifically about treaties. And treaties are formal and signed document entered into by states. And it can only be binding between parties that signed and ratified. So non-signatories could not be forced to obey such. And if you heard the word protocol or protocols, it means an amendment, an addition, or an alteration, or a modification of the existing treaty. And treaties could be multilateral or composed of several states, and bilateral, which is composed of two states only. And the VCLT or the Vienna Convention on the Law of Treaties is an example of a multilateral treaty. And to give you as an example, bilateral treaties could be tax treaties or like military treaties between two states. As an example of a tax treaty would be like the Philippines would enter into a tax treaty with the United Kingdom or Sweden or some states around the world. So I hope for now you learned something, no matter how short the lesson. And please wait for the second part, which will be published this Thursday. And hope that you share our Facebook page and tell those people who you know who are taking law school now. And please don't forget to subscribe our YouTube channel so that your you will find out the rest of our videos there from the beginning. Thank you so much for listening, and I hope that I will see you and you will look forward to Thursday. Thank you. Thank you. Have a good day.